Hello students and welcome to the lecture. So students, as we know that we are covering the parliament and basically these are the topics that we have scheduled for the discussion under this particular series. And if we talk about the topics that we have covered so far, so basically we have done with the introduction part, organization of parliament, composition of two houses, system of elections to Lok Sabha, duration of two houses, membership of parliament, presiding officers of parliament, leaders in parliament, sessions of parliament, devices of parliamentary proceeding, legislative procedure in parliament, joint sitting of two houses, budget in parliament, multifunction role of parliament, and ineffectiveness of parliamentary control. So these are those topics that we have covered so far. If we talk about the topic that we are left with is the position of Rajya Sabha, parliamentary privileges, and the sovereignty of parliament. Okay, so it means that out of 18 we have covered the 15 topics and now last 3 topics are remaining. Okay, so I hope that you have revised the previous lectures in the well enough manner before you have come for this lecture. As many a times I have told you, that is for your own benefit. So if you are doing this on the regular basis, the thing will be much more beneficial for you. If not, then you will face some difficulties. Okay, so now we are going to talk about the position of Rajya Sabha. So let us recall several facts and figures that we had covered in the previous lectures already. Like if we talk about the parliament, we know Indian parliament is a bicameral parliament, means that we have the two houses, Rajya Sabha and the Lok Sabha. Rajya Sabha represents the House of States, whereas the Lok Sabha represents the House of People. Okay, Rajya Sabha having the indirect elections, it means that the normal public could not elect the persons to the Rajya Sabha. Basically, the state legislative assemblies represent the persons in the Rajya Sabha and basically they elect them. Alright, here if we talk about Lok Sabha, we know that there is a provision of general elections and you can say there is a direct elections. The people could vote and select the candidate for the Lok Sabha. Alright, and thereafter if we talk about some more facts, so we can say the Rajya Sabha is the upper house. Why? Because it could not be dissolved, whereas Lok Sabha is the lower house and this could be dissolved. Alright, we know the Rajya Sabha having no tenure as per the constitution. Remember, the constitution has not provided for any particular tenure for the members of Rajya Sabha. This is totally dependent upon the parliament. As per this, parliament has fixed the Rajya Sabha tenure up to 6 years. Got it? These are the things. There are total 253 seats, 250 seats basically. Out of this, 230 are basically the elected seats and 20 are the nominated seats. And from where the people get nominated, if the person having the special knowledge of science, arts, literature and social services, then he will be nominated to the Rajya Sabha by the President of India. Okay, so these are some facts that we have recalled right now. Let's talk about. So if we look at the constitutional position of the Rajya Sabha as compared with the Lok Sabha. Okay, so basically this could be studied from 3 angles. There are 3 angles through which we could study it. And what are these angles? First is where Rajya Sabha is equal to the Lok Sabha. It means that both the houses having the equality. Okay. First angle. Second, where Rajya Sabha is unequal to Lok Sabha. It means that both the houses are not equal in terms of constitutional powers and privileges. Third is where Rajya Sabha has special powers that are not at all shared with the Lok Sabha. It means that Rajya Sabha is much more powerful in comparison with the Lok Sabha. Okay, so these are the 3 angles in which we could study the constitutional positions of the Rajya Sabha in comparison with the Lok Sabha. Got it? First, when both are equal. Second, when both are unequal. Third, in which Rajya Sabha having the upper hand than the Lok Sabha. Got it? So let's move forward. First is equal status with Lok Sabha. Okay, here both the Rajya Sabha and the Lok Sabha are equals to each other. In the following matters, the powers and status of the Rajya Sabha equal to that of the Lok Sabha. Okay, it means both the houses having the equal powers as per the constitution. And what are these? Let's understand them one by one. First, introduction and passage of ordinary bills. We know the ordinary bills goes through the 5 stages before including and recording in the Statute of India. First is presentation of the bill. Second is discussion. Third is scrutiny. Fourth is bill in the other house. Fifth is assent of the president. Okay, these are the 5 steps and these are incorrect. Because the correct steps are first, the presentation, second, the examination, third, the voting and discussion, fourth, bill in other house, and fifth, the assent of president. Okay, if you haven't revised them, then I know you didn't get the mistake in the steps. That's why I repeated them. And this is for you to recall that you have to revise the sessions. Okay, so basically in the case of ordinary bills, both the houses having the same stages. Okay, after this, next is the introduction and passage of the constitutional amendment bills. Introduction and passage of the constitutional amendment bills. Okay, this is the second stage. In the constitutional amendment bills, we know in either house of the parliament, whether it's Lok Sabha or Rajya Sabha, the constitutional amendment bill could be presented. Okay, and even this could be presented by either the minister or a private member. Minister is the person who holding any particular ministry or department. Private member is the person who is the member of parliament but does not have any ministry or department. Thereafter, introduction and passage of the financial bills involving the expenditure from the Consolidated Fund of India. Got it? After this, elections and impeachment of the president. Both the houses have the same power. Now here we are talking about the financial bills. Please do not attach it with the money bills because they have the different procedure. Okay, financial bills are very much similar in presentation to the ordinary bills. Okay, so whatsoever the steps we followed in ordinary bills, the same kind of steps we do follow in the financial bills. While we talk about the money bills, then remember, money bills are not presented to the Rajya Sabha. They could only be presented in the Lok Sabha with the prior consent of the president and by the finance minister only. Got it? And we know in the matters of the, you can say the money bills, the Lok Sabha having the upper hand in comparison with the Rajya Sabha. Got it? So here we are talking about the financial bills. Please keep that thing in your mind. Please do not connect it with the passing of the money bill, because if you do so, you will get confused. I can, you can say guarantee it to you. You will get confused. Okay. Election and impeachment of the president. Yes. All right. Thereafter, election and removal of the president. However, there is one thing. However, Rajya Sabha alone can initiate the removal of the vice president. Okay. It means that there is no need of initiation by the Lok Sabha also. He is removed by a resolution passed by the Lok Sabha by an effective majority, and this is a type of special majority, and agreed to by the Lok Sabha by the simple majority. Okay, so we can say the resolution to remove the vice president, who is also the chairperson and the chairman of the Rajya Sabha. This could be initiated alone in the Rajya Sabha, and the resolution should be passed by the effective majority or the special majority. Got it? And Lok Sabha is required to agree on this resolution, and they could do it by pass the resolution with simple majority. It means that they do not require the special majority. After this, making recommendation to the president for the removal of Chief Justice and the judges of Supreme Court and High Courts, Chief Election Commissioner and Comptroller and Auditor General. Why? Because the removal of them could only be done by the impeachment process, and the impeachment process should be passed by the special majority of the houses. Okay. After this, approval of ordinances issued by the president. We know when the parliaments are not in session, because the parliament having the three sessions only, the budget session, the monsoon session and the winter session. So if there is a condition in which the parliament is not in the session, and then you can say some position arises, and you can say some condition arises which requires the immediate action, okay, then it is the power given to the president, then he could pass the ordinances. Okay. And after this, what will happen? Whenever the parliament will meet again, it means that suppose after the budgetary session in the month of June, some condition arises due to which the president is required to pass the ordinances, and he did this. Okay, he passed the ordinance. So in the July, when the monsoon session will start and the parliament meet again, the parliament will get the tenure of 6 weeks. Within 6 weeks, the parliament is required to pass the resolution again. Okay, and if the parliament fails to do it, the ordinance passed by the president will have no force. Okay, so the approval and the passing of ordinances issued by the president, both the houses having the equal powers. After this, approval of proclamation of all three types of emergencies by the president. Okay, remember, only in approval they have the equal powers. In the revocation of this, the Lok Sabha could alone pass the resolution by the simple majority. Okay, there is no need to include the Rajya Sabha in it. So these are the some powers. After this, selection of ministers including the prime minister. Under the constitution, the ministers including the prime minister can be members of either house. Okay, and this is, you can say, some kind of different thing than the British Parliament. Like, let me tell you one thing and let me remind you, not telling. While we were discussing the you can say borrowing of the constitution, then we had discussed the parliamentary system has been borrowed from the British Parliament. Got it? And the British Parliament also a bicameral system like India we have. Okay, they have two houses, House of Lords and the House of Commons. Got it? We have two houses, Lok Sabha and Rajya Sabha. Got it? So basically, in British parliamentary system, whosoever will be the head of the government or the prime minister, the person should belong to the House of Commons. Okay, lower house. But when we talk about India, in India, whosoever will be the head of the government, or you can say the prime minister. Okay, the prime minister, he or she not required to be the member of the Lok Sabha. He could be a member of either house. Okay, means Lok Sabha and Rajya Sabha. But here is one thing, irrespective of their membership, they are responsible only to the Lok Sabha. For example, there is Mr. X, who is the member of Rajya Sabha, and then he got as in prime minister. Okay, so basically he having the membership of Rajya Sabha, but because he is the prime minister, so he will have the responsibility towards Lok Sabha only. He could not be responsible for the Rajya Sabha. Why? Because in India, ruling party governs the nation, and the ruling party and the council of ministers belong to the Lok Sabha. So that's why prime minister, who is the head of that council, will automatically or ultimately will have the responsibility towards the Lok Sabha. Got it? After this, consideration of the reports of the constitutional bodies like the Finance Commission, like the Union Public Service Commission, like the Comptroller and Auditor General, etc. These are the constitutional bodies which are defined with some special tasks. Alright. So whatsoever reports they will present to the Parliament. In discussion and the consideration of these reports, both the houses, whether it's a Rajya Sabha and the Lok Sabha, they have the equal powers. Okay. Enlargement of the jurisdiction of the Supreme Court and the Union Public Service Commission. If we talk about the Supreme Court, so let me tell you one thing straightforwardly. In India, the Supreme Court, you can say, always defined as a guardian of the Constitution. Why? Because the Supreme Court having the responsibility to protect the constitutional provisions. Alright? That's why the Supreme Court also enjoys the constitutional independence. And you can say the Supreme Court having the independence from the Constitution, that the government, or you can say even the Parliament, could not curtail the jurisdiction of the Supreme Court, but could only enlarge it. Same with the Union Public Service Commission. Thereafter, if we talk about the unequal status with the Lok Sabha, so what are these? So in the following matters, the powers and the status of the Rajya Sabha are unequal to that of the Lok Sabha. The first thing that we had already discussed, a money bill could only be introduced in the Lok Sabha and not in the Rajya Sabha, the Rajya Sabha having no equal powers like the Lok Sabha in that case. Second, Rajya Sabha cannot amend or reject a money bill, but they should return the bill to the Lok Sabha within 14 days and they could do some recommendations, alright, but could not modify it by themselves. It means that the recommendations which the Rajya Sabha will give to the Lok Sabha on the money bill, that will only on the advisory. Okay. Lok Sabha can either accept or reject all or any of the recommendations of the Rajya Sabha. In both the cases, the money bill is deemed to have been passed by the two houses. It means that the Lok Sabha having the upper hand in this case. After this, if we talk about the financial bill, not containing solely the matters of Article 110. Okay. It means that 110 article stands for the money bill. Alright. So if there is any financial bill that having no resemblance with the 110, that could be only introduced in the Lok Sabha and not in the Rajya Sabha, but both the houses having the equal powers in the passing. Introduction would be exclusive, but the passing would be equal. The final power to decide whether the particular bill is the money bill or not is vested with the Speaker of the Lok Sabha, and once the bill got passed by the Lok Sabha and the bill goes to the Rajya Sabha, basically the Speaker is the one who authenticates the following bill as a money bill or not. Got it? The Speaker of the Lok Sabha presides over the joint sitting of both the houses. Rajya Sabha with greater numbers wins the battle in the joint sitting, except when the combined strength of the ruling party in both the houses is less than that of the opposition parties. That we had already discussed in the previous lectures. Rajya Sabha can only discuss the budget but cannot vote on the demands for grant, and this is the exclusive privilege of the Lok Sabha only. Alright. After this, a resolution for the discontinuance of the national emergency can be passed only by the Lok Sabha, not by the Rajya Sabha, but the proclamation could be discussed by both the houses. Rajya Sabha cannot remove the Council of Ministers by passing a no confidence motion. This is because the Council of Ministers is collectively responsible to the Lok Sabha only. That's why if the Prime Minister belongs to the Rajya Sabha, even he is only responsible to the Lok Sabha. But the Rajya Sabha can discuss and criticize the policies and activities of the government. After this, the special powers of the Rajya Sabha. If we talk about them, Rajya Sabha having the 4 exclusive or special powers that are not enjoyed by the Lok Sabha. First is, can authorize the Parliament to make a law on a subject enumerated in the state list, Article 249, we had already discussed. Can authorize the Parliament to create all India services in the new form, common to the both center and states, Article 312. Can alone initiate a move for the removal of the Vice President because he is the chairman of that house. Other words, a resolution for the removal of the Vice President can be introduced only in the Rajya Sabha and not in the Lok Sabha as per the Article 67, because Lok Sabha having nothing to do with the chairman. If a proclamation is issued by the President for imposing the national emergency or the presidential rules of national emergency at a time when the Lok Sabha has been dissolved or the dissolution of the Lok Sabha take place within the period allowed for its approval, proclamation can remain effective even it is approved by the Rajya Sabha alone as per the Articles 52, 56 and 60. Thereafter, an analysis of the above points make it clear that the position of Rajya Sabha in our constitutional system is not as weak as that of the House of Lords in the British constitutional system, nor as strong as that the Senate in the American constitutional system. It means that we are in the mediocre way, not so too strong, not so too weak. Except in financial matters and control over the Council of Ministers, the powers and status of the Rajya Sabha in all other spheres are broadly equal and coordinate with that of the Lok Sabha. Okay. After this, we can say, even though the Rajya Sabha has been given less powers as compared with the Lok Sabha, utility is supported on the following grounds. First, its check has stayed effective, careless, and ill-considered legislation made by the Lok Sabha by making provision of revision and thought. Okay, it means recommends the modification. It facilitates the giving representation to eminent professionals and experts who cannot face the direct elections. The president nominates 12 such persons to the Rajya Sabha. Okay. It maintains the federal equilibrium by protecting the interests of the states against the undue interference by the center. Because the Lok Sabha mainly comprise of the central level, while the Rajya Sabha having the background from the states, so that's why they could put the states' interests in front of it. Okay. After this, the next thing that we are going to see is the parliamentary privileges. So what is the meaning of the privileges and all? So we can say parliamentary privileges are some kind of special rights, immunities, exceptions enjoyed by the two houses of parliament, their committees and their members. Okay. Remember that these are some kind of special rights, immunities and exceptions. And they are necessary in order to secure the independence and effectiveness of the elections, because if the parliamentary members are not having some kind of privileges, so what will happen? That they will not so speak freely, they could not so present it, the facts and figures more openly. Without these privileges, the House can neither maintain the authority, dignity, honor, nor can protect their members from any obstruction in discharge of their parliamentary responsibilities. Got it? The Constitution has also extended the parliamentary privileges to those persons who are entitled to speak and take part in the proceedings of the House of Parliament or any of its committees. It means somehow having a relevance with the Parliament. Okay. This includes the Attorney General of India and the Union Minister. The Attorney General of India is also having the right to sit and speak in the parliamentary proceedings, but he does not have any voting rights. Why? Because he is ex officio member of the Parliament, and as we have discussed already, the ex officio members are those who could sit and who could speak, but they could not vote in the passing of any bill and the resolution. Here, it must be clarified that the parliamentary privileges do not extend to the president. Why? Because the president is not a part of the parliament, and you can say not a part of either house, whether it's Lok Sabha or Rajya Sabha, but he is the integral part of the parliament. Alright, so he is not the one who takes the part in the parliamentary proceedings like the ordinary parliamentary member. Okay, yes, he could addresses the house. Yes, he could give his assent to the bills and resolutions passed by the houses, but he is not the one who will present, sit and vote in the parliament. Why? Because he is integral part of the parliament, he is not a member. Okay, this is the thing. If we classify the parliamentary privileges, so basically they are classified in two broad categories. First, those are enjoyed by each house of parliament collectively. It means that both the houses enjoys them, Rajya Sabha and Lok Sabha. Second, enjoyed by the members individually. Okay, so if we take them down one by one, first is the collective privileges. It means that belonging to each house of parliament collectively, it has a right to publish its reports, debates and proceedings, also the right to prohibit others from publishing the same. 44th Amendment Act of 1978 restored the freedom of press to publish true reports of the parliamentary proceedings without prior permission of the House, but not applicable in the case of secret sitting of the House, which are oftenly called at the national issues and national security issues. Okay. It can exclude strangers from its proceedings and hold secret sittings to discuss some important matters. Like we know, in India, you can speculate the parliamentary proceedings if you want to. All right. But in the normal sittings, whenever there is a secret sittings, no outsider is allowed to sit in the parliamentary houses. Can make rules and regulates its own procedure and conduct of its business and adjudicate upon such matters. They are allowed to do so. Can punish members as well as outsiders for the breach of their privileges or contempt by reprimand, admonition, or imprisonment. Also, suspension or expulsion in case of members. So these are some disciplinary actions and the tools that the parliament uses against the person who violates the rules. It having the right to receive immediate information of the arrest, detention, conviction, imprisonment, and release of a member of the parliament. Can institute inquiries and orders the attendance of witnesses and send for relevant papers and records. The courts are prohibited to inquire into the proceedings of the House or its committees, but they could only discuss the outcome of them. No person, either a member or outsider, can be arrested, and no legal process, whether in the civil cases or criminal, can be served within the precincts of the House without the permission of the presiding officer. It means that no outsider and the member could be arrested in any case if the member and the person sitting in the parliamentary premises without the permission of presiding officers. If we talk about the individual privileges, you can say enjoyed by the members only. They can be arrested, they cannot be arrested during the session of parliament and 40 days before the beginning and 40 days after the end of the session. Privilege only applicable in civil cases, not in the criminal cases or preventive detention cases. About preventive detention, we had already discussed in the fundamental chapter. They have freedom of speech in parliament. No member is liable to any proceedings in any court for anything said or vote given by him in the parliament or its committees. Freedom of speech subject to the provisions of the constitution, to the rules and standing orders regulating the procedure of parliament. It means that they also having some restrictions. They are exempted from jury service. They can refuse to give evidence and appear as a witnesses in a case pending in the court when the parliament is in the session. When the parliament is not in the session, they are required to present in the court. Breach of privilege and contempt of the House, if we talk about it, when any individual or authority disregards or attacks any of the privileges, rights and immunities, either of the member individually or the House in the collective capacity, offence is termed as the breach of privilege and punishable by the House. Any act or omission which obstructs the House of Parliament, member or its officers in the performance of their functions, which has a tendency directly or indirectly to produce results against the three things, the dignity, the authority and the honor of the House, is oftenly treated as a contempt of the House, and this is punishable offence. Though the two phrases breach of privilege and the contempt of the House are used interchangeably, but they have the different applications. Okay, so these are the things. After this, if we move forward, normally a breach of privilege may amount to contempt of the House. Likewise, contempt of the House may include a breach of privilege also. Contempt of the House, however, has wider implications. There may be contempt of the House without specifically committing a breach of privilege. Similarly, actions which are not breaches of any specific privilege but are offences against the dignity, authority and the honor of the House amount to the contempt of the House. For example, the disobedience to the legitimate order of the House is not a breach of privilege but can be punished as a contempt of the House. Okay, so students, basically in this lecture we have finished till here. In the next lecture we would continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture. Be ready for the another lecture. With this note, let's end this lecture, and what we say thank you.